Right now, millions of American parents are making one simple banking decision that can redirect their money in seconds, trigger family conflict, and in some cases, expose savings they spent decades building. I'm talking about adding a child or relative as a joint owner on a bank account. It sounds harmless, it sounds practical, it sounds like the easy solution if you want help paying bills. But that one signature can change who legally owns that money, who can take it, who can inherit it, and whether your will even matters. In this video, you'll learn what a joint account really does, why it can create tax and legal trouble, and what safer options may protect your family better. Let's get into it, starting with the part most people miss. There is one specific rule about joint accounts that can completely override your will, and I'll show you exactly how it works at the end. Most parents think, I'm only adding my daughter for convenience, or my son would never touch the money. But the law does not always care what you meant. It often cares how the account is titled. And that single detail can decide who gets the money after death, who can access it during life, and who may be exposed if something goes wrong. Write this down. Convenience in the bank can become chaos in the estate. And this ties directly back to that rule I mentioned earlier. A joint bank account is not just access, it can mean ownership. Here's what changed. The moment you add another person as a true joint owner, the bank may treat that person as someone with full rights to the money. In many joint accounts, each owner can withdraw funds. Each owner may be treated as having equal rights. And in many cases, when one owner dies, the surviving owner gets the balance automatically, depending on how the account is set up. The CFPB says the outcome depends on how the account was held, and notes that many joint accounts are held with rights of survivorship, meaning the money passes to the surviving owner. The FDIC also explains that joint accounts generally involve co-owners with equal withdrawal rights. What it means for you is simple. If you put your child on the account, you may have given that child more power than you intended. Not helper status, not emergency backup status, real legal access. That means your child may be able to move money, withdraw money, or be treated as an owner for certain purposes. And if your real goal was only to let someone help with bills, a joint account may be far more aggressive than what you actually wanted. Stop. This is where most families get it wrong. Parents think intention controls everything. It does not. Paperwork controls everything. If the bank form says joint owner, you may have changed the legal picture immediately. That does not automatically mean your child will misuse the money, but it absolutely means the risk is no longer theoretical. The risk is active. What you should do is ask one direct question. Did I add a helper or did I add an owner? Call your bank and ask how the account is titled. Ask whether it includes rights of survivorship. Ask whether both parties have full withdrawal rights. If your goal is bill-paying help, not ownership transfer, you may need a different setup entirely. A power of attorney may be safer in some cases. A convenience account may exist in some states or institutions. A payable on death designation may be better if your goal is inheritance, not present ownership. So what does this mean for you? It means you should confirm exactly what legal rights you created before assuming the account is harmless. A joint account can bypass your will completely. Here's what changed. Many parents believe their will controls everything after death. It does not. Some assets move outside the will. Joint accounts are often one of them. Nolo explains that most joint bank accounts come with a right of survivorship, meaning when one owner dies, the other automatically becomes the sole owner without probate. The CFPB says the same basic idea applies to many joint accounts, depending on how they were titled. What it means for you is this. You may think your will says, split everything equally among my 3 children. But if one child is the surviving joint owner on your bank account, that money may go straight to that child, not through the will, not through probate, and not through your intended equal division. That is where heartbreak begins. One child says, Mom wanted me to share it. Another says, no, the will says equal. And the bank says, we already paid the surviving owner. That is how family fights start after a funeral. Let me simplify this. Your will speaks to property inside your estate. A survivorship account may move outside your estate. That means your written wishes can lose to your account title. And this ties directly back to that rule I mentioned earlier, because the hidden danger is not what you meant. It is what the survivorship language does after death. Here's what no one is telling you. Parents often create unfairness by accident. They add one child because that child lives nearby, or because that child helps with errands, or because it felt easier at the bank. But after death, the other children may see that account as a secret side inheritance. Even if the child on the account is honest, the conflict alone can tear a family apart. What you should do is make sure your account titles match your estate plan. If your will says equal shares, your bank accounts should not quietly say something else. Review every checking account, savings account, and CD. Match the title, the beneficiary designation, and the estate documents so they tell the same story. So what does this mean for you? It means you should never assume your will controls a joint account without checking the survivorship rules first. The tax consequences are more complicated than most parents realize. Here's what changed. Many people think joint accounts are only an estate issue. They are not. They can also create tax questions. The IRS says that generally, transferring property or an interest in property for less than full consideration can be treated as a gift. The IRS also says a gift tax return, Form 709, may be required when gifts to someone exceed the annual exclusion amount for the year, even if no tax is ultimately due. For 2025 and 2026, that annual exclusion is $19,000. What it means for you is this. Simply adding a child to an account does not always create an immediate tax bill. But if that child uses money for their own benefit, or if ownership is treated as transferred, you may have entered gift territory faster than you expected. And once money starts moving, the paper trail matters. If large amounts leave the account, your family may later need to explain whether those were gifts, reimbursements, caregiving payments, or something else entirely. Write this down. Unclear money movement creates clear problems. If your child is paying your bills from a joint account, that is one thing. If your child is taking money for personal use, that can be very different. And if no records exist, it becomes much harder for your executor, your CPA, or your family to sort out what happened. There is another issue many people miss. Basis rules can differ between jointly owned property and inherited property. IRS Publication 559 explains that basis for a surviving joint owner may involve combining the survivor's original basis with the value of the decedent's share, rather than assuming the same clean step-up people often expect with inherited assets. That matters more with investments and appreciated assets than with a plain checking account, but the mindset is important. Joint ownership can change tax results in ways families do not anticipate. Stop. This is where most families get it wrong. They focus on probate and ignore records. But the IRS cares about transfers, ownership, and reporting. Your executor cares about documentation, and your family cares about fairness. If the money story is messy, the emotional story gets messy too. What you should do is keep records of who contributed the money, who used it, and why. If large sums move to a child, ask your CPA or estate attorney whether gift reporting applies. Do not wait until after death, when memory fades and suspicion rises. So what does this mean for you? It means you should treat a joint account like a legal and tax decision, not just a family favor. A joint account can expose your money to someone else's problems. Here's what changed. The second owner on the account is not just a name. That person is now tied to the account in a way that may create outside risk. If your child is sued, in debt, divorcing, pressured by creditors, or making poor financial choices, your money may not feel as protected as it did before. Even when state law varies on how much a creditor can reach, the risk of account scrutiny, freezing, dispute, or pressure rises the moment another owner is attached. What it means for you is deeply personal. You may trust your child completely and still have a problem. Trust is not the only issue. Life is the issue. A divorce can happen. A lawsuit can happen. Debt collection can happen. Bad advice can happen. Even simple confusion can happen if a bank, a court, or another family member sees the child's name sitting next to yours on the account. Suddenly, the money you intended for your own care can become entangled in someone else's mess. Here's what no one is telling you. Joint ownership also reduces your control emotionally. Many parents stop speaking up once a child is added. They feel embarrassed asking questions about their own money. They delay changes because they do not want conflict. And that creates a dangerous shift, especially if health declines later. And this ties directly back to that rule I mentioned earlier. The more ownership you hand away now, the less control your estate may have later. The hidden rule is not only about death, it starts affecting power while you are still alive. What you should do is ask whether your goal is help or shared ownership. If the answer is help, consider a structure that does not expose the account the same way. Review your documents before a crisis begins, not during one. The best time to fix this is when everyone is calm. So what does this mean for you? It means you should protect your money from other people's life events by avoiding unnecessary joint ownership. There are safer alternatives for most families. Here's what changed. Parents used to think the easiest answer was putting a child on the account. But safer tools exist. Nolo explains that a payable on death, or POD designation, lets you name who inherits the money at death without making that person a current co-owner. The CFPB also points people to legal roles for managing someone else's money, including powers of attorney, and its guidance for fiduciaries stresses keeping the older adult's money separate from the helper's own money and avoiding joint accounts. What it means for you is that you may not need a joint account at all. If your goal is inheritance, a POD designation may do that job more cleanly. If your goal is bill-paying help during life, a properly drafted financial power of attorney may be the better tool. If your situation is larger or more complex, a revocable living trust may provide stronger control and clearer instructions. Let me simplify this. Joint account means you own this with me now. POD means you get this when I die. Power of attorney means you can help manage this for me under legal duty. Those are not the same thing, and too many families use the first one when they really needed one of the other two. What you should do is review your accounts with your estate attorney or elder law attorney and ask, what is the least risky tool that solves my actual problem? That one question can save your family years of stress. So what does this mean for you? It means you should choose the tool that matches your goal instead of defaulting to a joint account. Here's the rule I told you to watch for. If your bank account is set up as a joint account with right of survivorship, that account can pass directly to the surviving owner and completely bypass your will. This is the part I want you to screenshot or write down, because this affects your estate directly. Your will can say one thing, your account title can say another, and in many cases, the account title wins. The CFPB says many joint accounts are held with rights of survivorship, and Nolo explains that when one owner dies, the survivor typically becomes the sole owner without probate. That is the hidden rule that catches families off guard. Source. So if you remember only one thing from this video, remember this. Adding someone to your account may do far more than let them help. It may hand them legal rights now, expose the money to outside risk, and send that money to them automatically later. That is why so many parents believe they made a simple banking choice when they actually changed their estate plan. Before you go, I have one question for you. Do you currently have a joint bank account with a child or family member? Type yes or no in the comments. I read every single one. Because the next video covers the biggest estate planning mistakes seniors are making in 2026, and you don't want to miss that. Also, go back to around 3 in this video. There's one detail most people completely missed the first time. And if this video helped you see the risk more clearly, stay close, because the families who avoid these mistakes are usually the ones who catch them early.